Thank you very much, and I hope you can all hear me. I have a voice that shatters glass, so it usually isn't a problem. I have to say, listening to that wonderful presentation by Frank, I thought, oh, that's a hard act to follow. However, Frank takes me into new realms, and I'm back down here on the ground, so away we go. I have to say, firstly, I'd like to acknowledge the traditional custodians of the land on which we meet and pay my respects to their elders past and present. But as previously Professor of Aged Services, I also like to acknowledge the elders of all the cultures that make up this wonderful country of Australia, including my own ancestors. I recently found a convict in the family tree. Yay! You realise, of course, that convicts are Australian royalty, don't you? And coming from Ireland, I thought, what did he do? Did he steal a loaf of bread to feed the starving children? Not in our family. He was convicted of bigamy. Now, it's interesting that this issue of advanced care planning, end-of-life issues, palliative care, is very, very topical at the moment, and I think it's become more so with the Royal Commission. But as I was coming here in a taxi this morning, I had a call from a radio journalist who wanted to talk to me about all of that. And I said, well, thinking about my diary for the next week or so, how does now suit? So I did an interesting radio interview in the taxi on the way here. So we're going to talk about palliative care in aged care, and mostly I'm going to focus on advanced care planning and other end-of-life issues. Now, the context for this is that better living conditions and healthcare have led to increased longevity. You may know that in 1901, average life expectancy in Australia was 45. And now for women it's about 85, and for men it's about 81. And there are currently over 4,000 people in Australia over 100. Despite what the shock jocks might tell you about an ageing population's going to wreck the health budget, it's not. The very, very oldest, when they go into hospital, don't have the very expensive invasive procedures, and people are living healthier longer as well. But it is a success story, and we should celebrate it as exactly that. In addition, rapid technological development has allowed people who would have previously died to be kept alive for long periods of time, often through the use of such things as ventilators and feeding tubes. But these successes have led to practical, legal and ethical issues, in particular around end-of-life care and extending the dying process. And as the number of older Australians grows, obviously the number of older Australians who die each year will also rapidly increase, and most will require care when they come to the end of their life, either in their own home or in residential, acute or palliative care. Now, when I do research out in the community, there is one question we often ask, and that is, if you were terminally ill, what do you think would cause you the most distress? In every study we did, loss of mental faculties came in first. And people often say to me, if someone's lost their mental faculties, it's possibly bothering everyone around them, even more than them. But it's what people fear most. Every study we did, loss of control came in second. In the first study, if you look down the list, you'll see that we had the second last item there. In the first study, we had extreme pain, and it came in at number 3. And then the research team said, why have we got extreme pain on this list? If someone's in extreme pain, they should sue their doctor. So we changed it simply to physical pain. And in the next study, it dropped down to number 6 in rank order. In the next study, it dropped down to number 8. And the more items we added in, the further down it went. And in every study we did, death itself came in last. People are mostly not afraid of dying. Some will be, and as Frank said, it's up to you to listen and hear that. But most people are not afraid of dying. They're afraid of things like loss of mental faculties, control, independence and dignity, and being a burden on families. Actually, every time I look at this slide, it reminds me of Woody Allen. Woody Allen said, "I'm not afraid of dying, I just don't want to be there when it happens." Well, I actually do want to be there, but I want it to be right. So advanced care planning can help to address some of these fears and concerns. Obviously not all, but think about what people fear. So if you're planning ahead for financial mechanisms, you'll be using a document called Enduring Power of Attorney for financial and property matters. But for health and personal care mechanisms, in New South Wales we have advanced care directives, we have Enduring Guardian, appointed by themselves or by the tribunal, and then there's a list of authorised decision makers if the person hasn't done their own planning. Now, the legislative basis for this in New South Wales is the Powers of Attorney Act for the financial matters and the Guardianship Act for appointing an enduring guardian. New South Wales and Tasmania are the only two states in Australia which don't have specific statute legislation for the advance directive. Now, when the working party on this was looking at the matter, Nick O'Neill, who was president of the Guardianship Tribunal at the time, said, we don't need statute legislation because they're already binding under the common law. Now, while he was correct, it left us with a bit of a problem. Firstly, we used to rely on UK common law because we hadn't had a common law case in Australia. And the case that I used to always refer to was Ray C., a man with a gangrenous leg. Doctors wanted to amputate. He said, I'd rather die with 2 legs than live with 1. They said, we'll wait till you lose capacity and we'll take it. And he said, no, you won't, and went to the High Court, who upheld his competently expressed wish pre-loss of capacity, which holds post-loss of capacity. But then Australia moved away from following UK common law, and we hadn't had a common law case. And I was hearing people say, oh, my doctor said they're not legally binding in Australia, or my solicitor said they're not legally binding. But somebody up there likes us, folks, because the first common law case in Australia happened in New South Wales. And this was a man who had severe renal failure. He went into hospital in Taree, went into renal failure and was put on dialysis, and shortly thereafter one of his friends arrived, and his friend had with him his own appointment as enduring guardian, but he also had a handwritten statement from this person saying that he was a Jehovah's Witness, and not only did he not want a blood transfusion, but he didn't want dialysis. Now, the Hunter Area Health Service did a very smart thing. They didn't oppose this. They simply contacted the Supreme Court and said, give us a declaration to say we may take him off, knowing he will die. And the court did that immediately, but the judge was reserving his judgment, and I'm going, please don't say it was because his enduring guardian said so. His enduring guardian could have said so. Now, the interesting thing about this case was, while his enduring guardian said he was with the man when he wrote the document, it wasn't signed. It wasn't signed by anybody, not even the person himself. So the first thing the judge had to do before he made the original decision was to have the handwriting forensically checked. And he took a stat dec from the enduring guardian as well. And when the judgment came out, it's a beautiful one. Anybody want a copy? Let me know. And it said, it went through all of the ways that a person with capacity can make their wishes known for loss of capacity. And it virtually came down to you can write it on the back of an envelope. And if there's evidence you've written it and no evidence you've changed your mind, it holds. Now, somebody told me yesterday that she tried to give someone in the RPA hospital in Sydney a copy of her mother's advance directive, and she was told, no, we don't accept those, they're not our forms. We don't accept those is not an option. So if anybody does, jump, like, you know, just imagine I'm sitting right behind you going, go on, go on. Jump up and down and tell them, that is not an option. They are legally binding. So, what is advanced care planning? Well, it's not a signature on a piece of paper. It's a process that allows a person to make and communicate in advance decisions about their health care, including medical and dental treatment, for a future time when they may have lost capacity. Ideally, it involves a discussion between the person and their healthcare provider and their family, friends, whatever, about their wishes and views about what they want or don't want, but it doesn't have to. Now, sometimes people say, oh, they didn't really understand. Many older people, people who are unwell, will be way ahead of anyone else around about what they think, what they know, what they want. And if they want to write an advance directive of their wishes without consulting anybody else, they can absolutely do that. As I said, ideally, we want them all, we want the process, but they don't have to. Of course, for it to be fully effective, it does include recording the decisions somewhere and appointing someone to see that they're carried out. So, as I've just said, it's a legally binding written document, which allows a person to make their wishes for future healthcare known, and it extends the current right of a competent person to accept or refuse treatment to a future time when they may not have capacity. It's not a form of euthanasia. It only allows actions which a person could consent to themselves if they were competent to speak, and it only comes into effect when the person who's making it has lost decision-making capacity. Now, just a brief aside here, I was thinking just as I was sitting there before about a case that I helped with. Having capacity doesn't necessarily mean that you can speak or write. I assisted a man in the PA spinal unit to complete his advanced directive, and all he could do was nod and shake his head. But there was a tribunal hearing where somebody tried to prove that he didn't have capacity, and like everywhere else in Australia, we work on the United Nations principle of presumption of capacity. I don't have to prove to you that I'm competent. I'm competent unless you can prove I'm not. And the tribunal said, you have not proven this man lacks capacity. So I was able to assist. He'd been on a ventilator, and he'd been taken off 3 weeks before, and he didn't want to go back on. And he'd been told, if you don't want to go back on, you will die. And he didn't want to go back on. So that man was able to complete the directive with his doctor, his wife, his mother present, and I witnessed it, and that man died 3 weeks later, and that was absolutely appropriate because he didn't want his dying prolonged by invasive technology. Went past that one, didn't I? Okay. So with an enduring guardian, a competent person over 18 can appoint someone to make personal and lifestyle decisions or decisions about their medical or dental treatment in case they lose the capacity to make their own. The person you appoint has to be over 18 and is usually a trusted relative or friend. You can't appoint your GP, you can't appoint the community nurse, you can't appoint somebody who's providing care for you in a paid capacity at home or in res care, and you can't appoint a relative of one of those. Sometimes when I do these presentations out in Western New South Wales, they say, well, that wipes out the community, at which point I say contact the tribunal. And you can appoint more than one, and you can say how they're to make their decisions. When I was doing mine, I phoned my son and I said, Steve, am I right in thinking you'd be happy to have my enduring power of attorney for finances, but you would prefer that Kim has my enduring guardianship for health matters? He said, oh, absolutely, Mum, because she'll do as you tell her and I won't. Oh, great. And he said, no, I know you. You'd say if I'm in that condition, don't let them do any more tests or operations. But I'd want to bring in every specialist that existed and keep you going to the last gasp. But Kim will do as you tell her. So I phoned my daughter and I said, is this okay by you? She said, of course it is, Mum, but isn't it typical? The boys get to look after the money and the girls get to do the caring. However, he has been warned that if she's away, because he's second on my form, if she's away and he has to make the decision, if he makes the wrong one, I'll come back and haunt him. Imagine being haunted by me. That'd be a bit challenging, wouldn't it? Okay. Whoever you appoint has to agree to the appointment and should understand your wishes and be prepared to carry them out. They also need to be tough enough to fight for your wishes to be respected. I'm going to talk a little bit about that as we go. And the appointment has to be in writing in the approved form, and there are a range of people who can witness it. The person who is appointed has the right to the same information that the patient would have if the patient had capacity. You know, sometimes people, okay, I'm someone's enduring guardian. Oh, right, you know, dismissed. There was one case in Sydney where it's still proceeding on its way, but absolutely the wrong person who had absolutely no authority was allowed to make decisions for this patient, and there are consequences for that. And again, it only comes into effect if the person has lost capacity. So what happens if there is no advance directive or enduring guardian? First thing I'll point out, it's in there somewhere in the slide, is that next of kin is totally irrelevant. Next of kin has no legal authority whatsoever. If the person has not appointed their own enduring guardian, if they have not written an advance directive, or they have and it doesn't meet the current situation, then in the legislation there is a an entity called person responsible, and it doesn't just mean anyone who's happy to take responsibility. There is a specified order of authority, which is the first readily available of a spouse, including de facto or same-sex partner, provided the relationship is close and continuing. If someone doesn't have a spouse or partner, it moves to non-professional carer. And the non-professional carer is often a younger daughter or daughter-in-law. And you'll get these big strapping lads come in and say, oh, mum's next to kin, so I get to make her decisions. Sorry, Sonny Jim, it's your sister that's been doing all the work and she gets to make the decision because she's probably much more likely to know what your mother would want than you are. And there was one case in the New South Wales Supreme Court, in the tribunal actually, where a woman had 3 children whom she hardly ever saw. She had a next-door neighbour who used to come in every morning and help her out of bed and put her washing on and take her to the doctor. When that woman lost capacity and the children started making decisions that the neighbour knew she wouldn't want, the neighbour applied to the tribunal and she was deemed to be carer under the meaning of the Act, because the legislation is based on the principle of patient autonomy. So what's patient autonomy mean? Who is the person who's most likely to know what this person would want? It's not a staff member in the facility either. Now, there are significant risks to patients and health professionals if the incorrect person consents to or refuses treatment. If the wrong person, firstly, it can risk the patient receiving care they don't want, or receiving treatment, they should always be getting care, but receiving treatment they don't want, or not receiving treatment that they would accept a trial of, because the wrong person has made the decision. Doctors and nurses are at far greater risk. They can be charged with assault if they provide treatment to someone on the say-so of the incorrect person. They can be